You know, most people probably think they have a pretty solid grasp on how the law defines major crimes.
Right, but when you actually look at the fine print, it's a completely different story.
Exactly. So for today's exploration into the source material, we are doing a deep dive into the legal mechanics of rape laws in the Philippines. Specifically, we're unpacking Republic Acts 11-1648 and 8505.
Along with Articles 266A and 266B.
Right. And our mission today is to understand why the law distinguishes between different modes of the crime and how it protects victims in a courtroom.
It's a pretty heavy topic.
It is. And just a quick note for our listeners, we are looking at these legal sources impartially. We aren't endorsing any specific political viewpoints. We're just here to convey the legal framework as it's written.
Definitely. And what is vital to understand right off the bat is that the law has evolved to be much more specific. We aren't just looking at one broad definition anymore.
No, we aren't. Article 266A actually splits the crime into two distinct modes. The first is what the law calls carnal knowledge.
Which is the traditional definition.
Yeah. A male offender using force, intimidation, or taking advantage of someone deprived of reason. So like if the victim is unconscious, drugged, or mentally incapacitated.
And the crucial legal nugget there is that penetration, however slight, makes the crime consummated.
Right. It completely shuts down that defense of, oh, well, the act wasn't finished.
Exactly. But if we connect this to the bigger picture, the second mode, sexual assault, is where the law really catches up to the 21st century.
How so?
Well, this mode can be committed by any person against any person. It covers things like oral or anal penetration or the use of instruments and objects.
So it completely removes the gendered assumptions.
Yes.
Yeah.
The law finally acknowledges that the gender of the offender or the victim doesn't change the trauma of the act. It is a huge shift toward inclusivity.
That makes a lot of sense.
Yeah.
Now let's pivot to how the law handles age. It is a tightrope walk between protecting kids and being realistic about peer relationships.
Under RA 11648, right?
Yes. The absolute rule is if a victim is under 13, consent is legally immaterial. It doesn't matter what was said, it is statutory rape, period.
No exceptions, but for victims under 16, there is this close in age exception.
Yeah, if the age difference is 3 years or less.
Right. And the act has to be consensual and non-exploitative. The intent there is to distinguish between teenage experimentation and predatory behavior.
Though non-exploitative is a really high bar. Based on the sources, this isn't just about saying yes, it's about the total absence of a power differential.
Which means?
If there is a teacher, a coach, or any abuse of trust involved, that close-in-age exception evaporates instantly.
Which leads us to the consequences. The law doesn't mess around here citing reclusion perpetua to death for what it calls qualified rape.
And just to clarify, reclusion perpetua is essentially life imprisonment. The death penalty is currently suspended in practice, but the statutes still mention it for cases involving deadly weapons, multiple offenders, or if the victim suffers insanity.
It stays on the books as a marker of how severe those qualified circumstances are. There is also the family factor.
Right, where the offender is a parent, guardian, or a relative within the third degree, and the victim is under 18.
It automatically triggers that maximum penalty. The law views the betrayal of that protective bond as a distinct heightened category of crime. Plus, there are special complex crimes like when homicide occurs by reason or on occasion of the rape.
Which also triggers the absolute highest penalty. So with all these severe guidelines, how does the law actually protect the person on the stand?
That is where RA 8505, the rape shield law, comes in.
Because the courtroom can be brutal.
Absolutely. This law basically says the victim's past sexual history or reputation is off limits. It prevents the defense from putting your character on trial to distract from the actual incident.
It keeps the focus entirely on the specific event.
Right. And it reinforces that a conviction can be based solely on the victim's testimony if it is firm, categorical, and straightforward. You don't necessarily need a mountain of physical evidence.
And the law actually helps the victim here with the legal presumption of non-consent.
Yes. If there is any degree of resistance or a condition making consent impossible, the law assumes consent was never given.
It stops the whole he said, she said narrative before it even starts.
It is a framework that really prioritizes vulnerability over broad generalizations.
It really does. So understanding these modes and shields is so essential for navigating the complexities of modern justice. Before we wrap up, though, here's a final thought for you to mull over.
Go for it.
If the law already presumes non-consent, The moment resistance is shown or capacity is lost, why does our broader public conversation still demand that survivors prove they said no loud enough?
That is a fascinating shift in perspective to think about.
Something to explore on your own. Thanks for joining this exploration into the source material, everyone.
All right, today we're diving into a topic that's incredibly serious, but also incredibly important to understand from a legal standpoint, the law on rape. We're going to set aside the headlines and opinions for a bit and look directly at what the law actually says, how it defines the crime, how it's prosecuted, and what the penalties are. So let's jump right in. So it all boils down to this one central question, right? We hear a lot about it, but what does the law actually say about rape? I mean, how does our legal system take this incredibly impactful act and define it in black and white terms? That's exactly what we're going to do. Peel back the layers and get to the core legal facts. And right off the bat, we hit on a huge fundamental shift. The law used to see rape as a crime against chastity, which kind of framed it as a crime against someone's honor or purity. But now, under this law, it's a crime against persons. And let me tell you, that is way more than just semantics. It's a complete reframing. It says the harm is done to a person, to their body, their safety, their very being. And that change has massive ripple effects on how the justice system approaches these cases. Okay, so Section 1, defining the crime. So how does the law get down to the nitty-gritty? Well, it gets super specific, because it's not just about the act itself. The law makes it crystal clear that the context, and really the absence of consent, is everything. So, the law lays out 4 key scenarios where consent is legally impossible. First up, the one we probably think of most often, when there's force, threat, or intimidation involved. Simple as that. Then, you have situations where the victim is deprived of reason or is unconscious. They literally can't consent. The third is a little more nuanced. It's about abuse of power. Think fraudulent machination or grave abuse of authority. And finally, the law draws a hard line in the sand for age and mental capacity. If the victim is under 16 or is demented, the law says they are legally incapable of consenting. Full stop. All right, moving on. Now that we know these circumstances that define rape, the law actually splits the crime itself into 2 different categories, or modes. So here's how that breaks down. On one hand, you have what the law calls rape of the first kind. This specifically refers to carnal knowledge, sexual intercourse, and for this one, the offender has to be male. But then you have rape of the second kind, and this is a much broader category. It includes other forms of sexual assault, like inserting an object or the penis into the mouth or anal orifice. And here's the really crucial difference. For the second kind, the law becomes totally gender neutral. It says any person can be the offender and any person can be the victim. That's a huge deal. Okay, next up, simple versus qualified rape. Now we're getting into how the law measures the severity of the crime, because this distinction has a massive impact on the punishment. So first, let's talk simple rape. Now, the word simple here is a legal term. It definitely doesn't mean the crime isn't serious. It's the baseline. It's the act of rape committed without any of the specific aggravating factors we're about to cover. But even for this baseline simple rape of the first kind, the penalty is reclusion perpetua. And what does that mean? Well, it's essentially life imprisonment, a minimum of 20 to 40 years behind bars before there's even a possibility of parole. So yeah, nothing simple about that. But then the law says, hold on. There are certain circumstances that can take this already horrific crime and elevate it to something even more severe in the eyes of the law. When those factors are present, the crime becomes qualified rape, and the penalties, well, they get much, much heavier. So how does that work in practice? It's pretty straightforward, legally speaking. First, you have the act of rape. Then, the prosecution needs to prove that one of these special qualifying circumstances was also part of the crime. If they succeed, boom, a more severe penalty is imposed. It's like a legal multiplier for the punishment. So, what are these aggravating factors? Let's break down exactly what qualifies the crime of rape, and we can sort them into a few key buckets. The first group is all about the victim's vulnerability. The law basically says that if you target someone who is especially defenseless, the crime is worse. We're talking about a victim who is under 7 years old, or if the offender knew the victim was pregnant or had a mental or physical disability. The law is providing an extra layer of protection here. It even covers a victim who is a religious figure, recognizing that unique position of trust. This next set of factors is just chilling. It's all about the offender's position of power or trust. The law imposes a harsher penalty when the offender is someone who is supposed to be a protector, a parent, a guardian, a close relative. It's a profound betrayal of trust. And that same logic extends to people in positions of public authority, like members of the police or military who take advantage of that power. Then we look at the circumstances of the act itself. The how of the crime can make it qualified. For instance, if it's committed by 2 or more people, or if a deadly weapon is used. And then there's this one, which is just unbelievably cruel. If the crime is committed in full view of the victim's own spouse, parent, or children. The law recognizes the added layer of trauma in these situations and punishes it more severely. And finally, the law looks at the aftermath, the sheer severity of the harm done. If the victim becomes insane as a result, if they suffer permanent physical mutilation, those outcomes qualify the crime. It's also qualified if the offender knowingly transmits HIV/AIDS or another serious STD. And of course, if homicide is committed because of the rape, well, that's one of the gravest offenses you can possibly have. Okay, so we've covered the what, the how, and the how bad. The final piece of the puzzle is this. How do you actually prove it in a courtroom? Let's get into the rules of evidence. Now, this is a really important technical legal point. For the crime to be considered consummated or completed, the law states that the slightest penetration is enough. The prosecution does not have to provide proof of omission. This sets a very clear, very low physical threshold for what constitutes the completed crime in the eyes of the law. Okay, now this is a legal principle that you absolutely need to understand. The law explicitly recognizes that rape is often a crime with no witnesses. Because of that, it says that the uncorroborated testimony of the offended woman can be enough to prove the crime. Now, that doesn't mean it's an automatic conviction. The court still has to weigh that testimony and find it credible, believable, and convincing. But it's a powerful statement that a victim's voice on its own can be enough to secure justice. And to make sure the victim is protected during the grueling process of a trial, the law has something called the rape shield rule. Think of it as exactly what it sounds like, a legal shield designed to stop the trial from turning into a public attack on the victim's character. So what does this shield actually block? Well, as a general rule, it makes certain types of evidence completely off limits in court. The defense can't bring up the victim's past sexual conduct. They can't introduce opinions about it. They can't talk about the victim's reputation. The whole point is to keep the trial focused on the facts of the case at hand, not to put the victim's life on trial. Now, there is a very narrow exception, but a judge has to be completely convinced it's relevant and absolutely critical to the case before allowing it. So let's just step back and look at the whole picture. When you add it all up, changing the definition to a crime against a person, creating these tiers of severity with qualified rape, and putting up these legal shields to protect victims in court, you can see a clear pattern. This isn't just a collection of dry legal rules. It's an architecture. It's the system trying to make a statement. Which brings us to our final thought. With all these changes, how is the law itself trying to completely reshape what the pursuit of justice looks and feels like for victims?
Welcome back to the deep dive. And I have to be honest with you right off the bat, the stack of research we're tackling today, it kept me up last night. It is heavy.
It is.
It is dark. But it is also one of those topics where if you don't understand the rules, you don't really understand the reality of the society we live in. We are looking at the legal framework of rape in the Philippines.
It is a heavy stack. You're absolutely right. I think people often shy away from the legal side of this because the crime itself is just so visceral.
Right.
We have this, this gut reaction to the word rape. We know it's a violation. We know it's wrong. But the law is cold. The Revised Penal Code and the amendments like Republic Act 8353 and the new RA 11648, they have to be precise. They have to draw lines in the sand.
And that's what surprised me the most going through this. I really thought I knew what rape was. But looking at how the Philippine legal system categorizes it, I realized I had no idea. It's not just one thing. It's a study in how the state actually defines violation. We're talking about the what, the how, and the who. And honestly, some of the things in here, like the fact that the law actually splits rape into 2 completely different species, I had never heard that before.
You're referring to the distinction between rape of the first kind and rape of the second kind.
Exactly. It sounds like something out of a sci-fi novel, the second kind, but it's the bedrock of the law.
It is. And Understanding that split is really the only way to understand why the penalties apply the way they do. It's not just technical jargon. It's about recognizing that sexual violence takes different forms, and the law, well, it had to evolve to catch up with that reality.
So here is the plan. We're going to unpack those two modes. We absolutely need to talk about the age of consent because that changed recently, and it's a massive deal.
A huge deal.
We're going to look at the aggravating circumstances, like what happens if a police officer is the one doing it, or a priest. And we have to talk about the procedural stuff, specifically this marriage pardon thing, which, look, when we get there, I have some serious questions because it blew my mind that this is still on the books.
It's a very unique feature of the penal code, for sure. And it creates a lot of tension between, let's say, modern justice and more traditional values.
Okay, let's jump in. We tend to think of rape as a single horrific act, a single narrative. But the law sees it through a bifurcated lens, Article 266.8a. It establishes these two modes. Let's start with rape of the first kind. To me, this reads like the traditional definition.
That's a fair way to put it. Rape of the first kind is what has historically, for centuries, been defined as rape in almost every jurisdiction. Legally, under Article 266a, paragraph 1, this mode is strictly biological.
Biological.
It is defined by the actors involved. The offender must be a male person.
Strictly male. So a woman cannot commit rape of the first kind.
Not as the principal actor, no. The law implies this because the act itself requires carnal knowledge. In the context of the Revised Penal Code, carnal knowledge is a legal term of art that specifically equates to sexual intercourse.
Which implies penile vaginal penetration.
Correct. So biologically, for rape of the first kind to occur, you need a male offender who is capable of penetration and a female victim. It maintains that very specific gendered binary.
Okay, let's drill down on capable of penetration. I feel like I've seen defense lawyers in movies and in the case files here argue about the completeness of the act. You know, like if a guy says, well, I didn't finish, or it wasn't a complete entry, does he get off the hook?
That is probably the single most damaging misconception out there. And the Supreme Court has had to, hammer this down repeatedly. There is a landmark case, you probably saw it in the stack.
Yeah, the Oscar case? Tell us about that.
So in that case, the defense actually tried to argue that because there wasn't full penetration, perhaps it was shallow or it was interrupted, that the crime wasn't rape. They were likely aiming for a lesser charge, maybe acts of lasciviousness or attempted rape.
Trying to knock it down a peg.
Exactly. But the Supreme Court drew a very, very hard line. They held that the slightest penetration of the female organ is sufficient to consummate the crime.
The slightest penetration.
Even if it is just touching the labia with the intent to penetrate and making that initial entry, it does not need to be a full or perfect penetration. It does not require the rupture of the hymen. The moment there is any entry into the vulva, the crime is consummated.
I think that's incredibly important because it shifts the focus from the success of the sexual act, if you can even call it that, to the violation of the boundary.
That's the heart of it. The crime is the violation of bodily integrity. The moment that boundary is crossed, the damage is done. The law isn't interested in whether the offender achieved sexual satisfaction. It's interested in the invasion of the victim's body.
Speaking of sexual satisfaction, that brings up the other biological side of things, emission. Sperm. There was another case, People versus Canastre. The defense argued that because the medical exam didn't find any sperm, it couldn't have been rape.
Right. The old no sperm, no rape argument. It's a very crude argument, but you see it come up. And again, the court shot it down emphatically. Proof of omission is not required.
But, playing devil's advocate here, if there's no sperm and maybe no tearing because of this slightest penetration rule, how do you prove it? Doesn't that make it incredibly hard to convict?
It makes the testimony of the victim paramount. And we'll get to evidence later, but legally, the absence of sperm proves nothing other than the fact that there was no ejaculation or, the evidence was washed away or it wasn't collected in time.
Right.
It doesn't prove that penetration didn't happen. The crime is the entry, not the deposit of fluid. If the victim testifies credibly that entry occurred, the lack of biological traces doesn't negate that.
Got it. So, first kind is about the act of intercourse, specifically male on female. But it's not just having sex, obviously. It has to happen under specific conditions to be a crime.
Right. Consensual sex is not a crime. The statute lists the specific circumstances that transform the act into rape. The most famous one, of course, is force, threat, or intimidation.
The one everyone thinks of.
Yes, but it also includes when the victim is deprived of reason or unconscious, or when it is done through fraudulent machination or grave abuse of authority. And, of course, the age factor we'll get into.
I want to hold off on force for just a second because that's a huge topic on its own. I want to pivot to the other side of the equation first. We just talked about first kind, but the law changed. It expanded. Enter rape of the second kind. Why did they need to add this? Was the first definition failing people?
Absolutely it was. Massively. Think about the limitations of carnal knowledge as we just defined it. It requires a penis and a vagina. So what happens if a man forces a woman to perform oral sex?
Under the old definition, that wasn't rape.
Under the old strict definition, that was not rape. It was maybe acts of lasciviousness or a form of sexual assault, which carried significantly lower penalties.
So you could violate someone in a horrific, traumatic way, but because of the body part used, you got a lighter sentence? That's insane.
Exactly. It created a profound injustice. The victim suffered similar trauma, but the law treated it as a lesser offense. So Article 266A, Paragraph 2, rape of the second kind, was created specifically to close that gap. And it fundamentally changes the who.
How so?
In rape of the second kind, the offender can be any person, male or female, and the victim can be any person, male or female.
So this removes the gender barrier entirely.
Completely. A woman can rape a man can rape a man, a woman can rape a woman. The law becomes gender neutral in this mode.
That is a massive shift. Acknowledging that this kind of violation isn't limited to one dynamic, and it changes the definition of the act too, right? It's not just intercourse anymore.
No. It covers sexual assault involving penetration by other means. The law breaks it down into two main categories. First, the insertion of the penis into the mouth or the anal orifice of another person.
Okay, so forced oral or anal sex is now legally rape with the same weight as vaginal rape.
Correct. Same gravity, same potential penalty. And the second category is even broader. It's the insertion of any instrument or object into the genital or anal orifice of another person.
Any instrument or object, that seems incredibly broad, but I guess it has to be.
It has to be. We've seen cases involving bottles, sticks, fingers. I mean, the law is trying to capture the reality of sexual violence, which is often about degradation and power, not just a biological sex act.
So just to be crystal clear, if a man assaults a woman with an object, that is rape of the second kind.
Yes.
And if a woman assaults a man using an object.
That is also rape of the second kind.
That really changes the landscape. It feels like the law finally caught up to the idea that the violation isn't about reproduction or traditional sex. It's about the intrusion, the unwanted intrusion.
Precisely. It levels the playing field of justice. Whether the invasion is penile vaginal or involves an object in a different orifice, the violation of the person's dignity and autonomy is the crime.
Okay, so we have the two modes, the biological first kind and the broader gender-neutral second kind. But both of them, regardless of the parts involved, hinge on those circumstances we mentioned. Force, intimidation, deprivation of reason.
Those are the triggers. Without one of those, or the age factor, it's just two people engaging in an act. Those circumstances are what negate consent.
Let's unpack force, because I feel like Hollywood and TV have really messed us up here. We have this image ingrained in our heads that for it to be real rape, the victim has to be fighting for their life.
Right.
Screaming, scratching, clothes torn to shreds.
Yeah.
If there are no bruises, the jury in the movie says not guilty.
The resistance to the death myth. It's dangerous, it's pervasive, and thankfully the Philippine Supreme Court has spent decades dismantling it piece by piece.
So let's talk about the irresistible force concept. That sounds like something out of a physics textbook.
It does, and there's a key case, People versus Momo. The defense argued that the force used wasn't irresistible, essentially saying the victim could have fought harder if she really truly wanted to.
Which is just classic victim blaming.
It is, but the ruling clarified that the force used by the offender does not need to be irresistible. It doesn't need to be a force that no human could possibly withstand.
So what's the standard then?
It only needs to be present enough to achieve the result. If the force used was sufficient to make that specific victim capitulate, that is enough. The law recognizes that fear is subjective and paralyzing. What might be manageable for one person could be overwhelming for another.
But aren't there cases where the court does look for resistance? I remember seeing People versus Lago in the research, the one with a hunting knife. That one seemed different.
People versus Lago is an interesting counterpoint, or rather an illustration of a different scenario. In that case, the victim shouted for help, she struggled, she kicked. The accused eventually overcame her by pressing a hunting knife to her throat.
A hunting knife.
Yes. And the court noted that she taxed her powers to the utmost. They commended her resistance.
See, that sounds like the Hollywood standard. Taxed her powers to the utmost.
In that specific case, yes, because she was physically fighting back until a weapon was introduced. But that doesn't mean every victim has to do that. The court highlights that resistance depends on the context. If someone pulls a knife immediately, you aren't expected to kick and scream.
Right. Of course not. If someone holds a knife to your throat, you stop fighting, you freeze. Your body goes into survival mode.
Exactly. And that leads us to a crucial legal concept: resignation versus consent.
This is the People versus Dio case.
Yes, that's the one. In People versus Dio, the issue was resignation. The victim eventually stopped fighting. Or in some cases, you see victims who are woken from sleep and are too terrified or confused to fight immediately. The court ruled that resignation to the act is not consent.
Resignation is not consent. That needs to be on a billboard.
It's a recognition of survival instincts. If you realize that fighting might get you killed, so you stop moving, you go limp, that is not you agreeing to the act. That is you trying to survive the act. The will is not consenting. It's just submitting to an overpowering force.
That makes total sense. But what about when there is no weapon? What if it's just pressure? Or the fear of the person themselves?
That moves us from force to intimidation. Intimidation includes moral fear. You don't need a gun. The research mentions a case, People versus Garcines. The victim was a 13-year-old girl. The offender was a large, older farmer.
So just the size difference.
The size difference, the age gap, the isolation of the setting, the sheer power dynamic created intimidation without a weapon being drawn. The child was paralyzed by the presence of this large man. That counts as intimidation.
This connects to the idea of moral ascendancy, doesn't it? This is about authority figures.
This is, I think, the darkest part of the intimidation element. Moral ascendancy is often seen in cases involving fathers, stepfathers, teachers, employers. The case of People versus Alinea deals with this head-on.
This is the father scenario.
Yes. When the offender is a father or someone with that kind of moral ascendancy over the victim, the law essentially dispenses with the need to prove determined resistance.
Why? Why is the standard different?
Because the coercion is inherent in the relationship itself. A child is conditioned to obey their father. They are taught to trust them. They cannot be expected to physically fight the person who represents all authority and safety in their life. The father's mere demand functions as the force.
That's heartbreaking, but I'm glad the law sees it that way.
Yeah.
It stops a defense lawyer from asking a 12-year-old on the stand, why didn't you punch your dad?
Exactly. It acknowledges that the force was applied psychologically long before the physical act ever happened. The violation of trust is part of the crime.
Now let's move to the other major circumstance, deprivation of reason or unconsciousness. We mentioned sleeping victims. I feel like this should be obvious, but apparently it has to be litigated.
It does, surprisingly often. People versus Caballero and People versus Corchino establish that intercourse while the victim is asleep or unconscious constitutes rape. The rationale is simple. The victim has no will to resist.
They can't consent.
They cannot. Consent requires a conscious yes, or at least a conscious participation. If you are asleep, you cannot consent. Therefore, any sexual act performed on you is, by definition, rape.
And this extends to intoxication. What if she's drunk or drugged?
Yes. The source material references People versus Bautista. It discusses a woman under the influence of a potion or who is in a state of lethargy produced by sickness.
A potion. That sounds very old school.
The language is old, but apply it to modern date rape drugs or even just extreme incapacitating intoxication. If the victim feels dizzy, weak, and experiences a sudden loss of control over her person, she is considered deprived of reason. She cannot give valid consent.
What about mental disability? The term used in the older text is demented or feeble-minded, which is obviously not the language we'd use today.
Right, a very dated terminology, but the legal principle stands. People versus Dang clarifies that the deprivation of reason doesn't need to be complete. You don't need to be totally catatonic. A mental abnormality or deficiency that compromises the ability to understand the nature of the act or give valid consent is sufficient.
So it's about the capacity to understand.
It is. Can this person truly comprehend what they are agreeing to? If the answer is no, then there can be no legal consent.
There was one specific exception I saw in the notes regarding deaf-mute individuals.
Yeah.
And I have to ask about this because at first glance, it seemed restrictive.
You're looking at People versus Nava. The court ruled that being a deaf mute does not automatically mean one is deprived of reason.
So just because someone can't speak or hear doesn't mean they can't consent.
Correct. Unless there is proof of imbecility, again, the older legal term for a severe cognitive impairment, a deaf-mute person is presumed to be capable of consent. They have agency. So, simply proving the victim is deaf-mute isn't enough for a rape conviction based on deprivation of reason. You would still need to prove force or threat, or that they clearly communicated a no through their actions.
That's a good nuance. It actually respects the agency of people with disabilities unless there is a specific cognitive issue.
Right. It prevents the law from infantilizing an entire group of people.
Okay, I want to shift gears now. We need to talk about one of the biggest changes in recent history. The age factor. Statutory rape. For the longest time, the age of consent in the Philippines, or rather, the age below which statutory rape applied, was 12.
Which was shockingly low by international standards. It was an outlier.
It was, but that has changed. Republic Act 1/1648. This was a big one.
This is a monumental shift in child protection. The threshold has been raised to under 16 years of age.
So, just to be crystal clear for everyone listening, if the victim is 15 years old, it is rape.
Yes. If the offended party is under 16, consent is strictly and absolutely immaterial.
Immaterial. Meaning it doesn't matter if they said yes, it doesn't matter if they initiated it, it doesn't matter if they have a history with the person.
It does not matter. The law presumes that a child under 16 lacks the maturity and capacity to fully understand the consequences of the act. The case of People v. Perez, which dealt with the older age limit but the principle is the same, even established that if the child was a prostitute, it is still rape.
Wait, really? Even if the child was engaging in sex work?
Yes. The court held that the profession of the child is irrelevant. A child is a child. You cannot buy consent from someone who legally cannot give it. That is a hard, bright line designed to protect children from exploitation in any form.
I think most people would agree with that.
Right.
And I know our listeners are screaming this at their speakers right now.
Right.
What about teenagers? What about high school?
The Romeo and Juliet scenario.
Yeah, exactly. If I'm 17 and my girlfriend is 15, am I a rapist? Under the strict letter of the law you just described, she's under 16, so she can't consent. So do I go to jail?
This is where the lawmakers had to be practical and introduce some nuance. RA 11C48 introduced a very specific proviso to handle this exact situation. It's an exception clause.
How does that work? Is it automatic?
It's not automatic in the sense that anything goes. It's a defense that can be raised. There is no criminal liability for a person having carnal knowledge of someone under 16, but only if 4 very specific conditions are met.
4 conditions. Let's list them.
Okay.
Because this is the difference between a high school romance and felony.
Okay. First, the age difference between the parties must not be more than 3 years.
3-year gap maximum. So 15-year-old and 18-year-old is okay. A 15-year-old and a 19-year-old, that's a 4-year gap. That's trouble.
That's trouble. The exception would not apply. Second, the sexual act must be consensual. Obviously, if there's any force or threat, the age gap doesn't matter, it's just rape.
Right, that's a given.
Third, the act must be non-abusive. The law defines this as the absence of undue influence, intimidation, or maltreatment.
So no power imbalance.
Correct. And fourth, it must be non-exploitative, meaning there's no taking advantage of vulnerability or a position of trust. It can't be a teacher and a student, for instance, even if the age gap is less than 3 years.
But it really has to be a peer relationship, equal footing, close in age, truly consensual.
Exactly. It's designed to decriminalize consensual experimentation between peers close in age. But, and this is a massive but that cannot be ignored, this exception never applies if the victim is under 13 years of age.
So under 13 is the absolute floor, no exceptions.
Absolute. Even if the boyfriend is 14 and the girlfriend is 12 and a half, that is statutory rape. The Romeo and Juliet exception creates a window between 13 and 16. Under 13 is an absolute protected zone where no sexual contact is legal, period.
That clarity is really helpful. It balances the reality of adolescent behavior with the absolute need to protect the youngest children.
It's a delicate balance, but a necessary update. The jump from 12 to 16 was huge, and this exception prevents the overcriminalization of normal teenage behavior while still catching the predators.
Moving on. We've established definitions and age. Now let's talk about penalties. Rape is already a heinous crime, but there are qualifying circumstances that escalate the penalty to reclusion perpetua, which is effectively life imprisonment or even death. I know the death penalty is suspended, but it's still in the statute books as the ultimate severity level.
Correct. Article 266B outlines these circumstances. It transforms what would be simple rape into qualified rape.
What makes it qualified? What are these factors?
Well, the list is extensive, but you can group them. Think of it as factors that make the crime even more repulsive or dangerous. The use of a deadly weapon is a major one. If you use a knife or a gun during the rape, the penalty maxes out.
And then there's multiple offenders. Gang rape.
Yes. The law is very strict here regarding conspiracy. The case People versus Villa is the standard. It established that if a conspiracy is found, meaning they acted in concert, everyone is liable for every act of rape committed by the group.
Can you explain conspiracy in plain English? Because that sounds like they sat down and signed a contract or something.
No. Think of it like a bank robbery. If you drive the getaway car, or you hold the door open, or you shout at the tellers, you are all bank robbers. You are all equally liable for the robbery.
So in a rape case, if that same logic applies.
If there are 4 men, 3 of them rape the victim, 1 of them just stands by the door to make sure no one comes in. Under the law, the guy at the door is liable for 3 counts of rape.
Even though he didn't touch her.
Even though he didn't touch her. This is based on cases like People versus Alfaro. Even if you are just the lookout, or if you are the one threatening the victim with a revolver while another person commits the act, you are a principal by direct participation or indispensable cooperation. Your presence and actions enabled the crime.
That is terrifyingly strict, but I get it. You're facilitating the horror, you are part of the machine.
Precisely. If you are part of the plan, you own the outcome. There's no "I was just the driver" defense.
Then we have the relationship qualifiers. This is about betrayal of trust. Incest is the most obvious. Parents, ascendants, step-parents, guardians. But there was a specific mention of public authority figures that really stood out to me.
This is a crucial protection against state abuse. If the victim is in the custody of the police or the military, or if the offender is a member of the PNP, the Philippine National Police, or the AFP, the Armed Forces, and they are taking advantage of their position.
It effectively says, we gave you power, we gave you a badge and a gun to protect citizens, and you used it to violate them.
Precisely. The law recognizes that betrayal of public trust requires the harshest penalty. It's an aggravating circumstance because the victim is often completely helpless against the authority of the state. They're supposed to be the protectors.
And it's not just police. It applies to prison guards too, right?
Yes. Anyone in charge of a penal institution.
There was one other category here that was similar. Religious vocation?
Yes. If the offender is a priest or a religious leader and the victim is a known religious follower, it's the same logic as the police provision. It's an abuse of spiritual authority and trust. The victim looks up to this person for guidance, for salvation even, and that trust is weaponized.
Finally, the physical consequences can qualify the rape. If the victim becomes insane, if they get mutilated or permanently handicapped,
or if the offender knowingly transmits HIV/AIDS or another sexually transmissible disease. That is a specific qualifier now. If you know you have the disease and you rape someone transmitting it, the penalty is maximized. It's seen as an additional life-altering assault.
I want to touch on a specific complex crime that gets its own category. Rape with homicide. How is this different from just committing a murder and also committing a rape?
It's a subtle but vital legal distinction. Rape with homicide is a special complex crime. It's treated as a single indivisible offense, not 2 separate ones. The key phrase in the law is by reason or on occasion of the rape.
Okay, give me an example of that. What does that mean?
A classic tragic example is People versus You. In that case, the accused raped a 6-year-old girl. Then he strangled her to death. Why? To silence her. To prevent her from telling anyone what he did. The killing was done because of the rape. The 2 are inextricably linked.
Okay, so the murder is a direct result of the rape to cover it up. What would be an example where they aren't linked in that way?
There was a case, People versus Las Spartas. This is a grim one. The victim was attacked and was already dying. She was at the threshold of death from a physical assault when she was ravished. The court viewed the rape there as a form of cruelty or ignominy, adding shame to the murder.
So the rape was an afterthought to the murder.
In a sense, it wasn't rape with homicide in the special complex crime sense because the killing wasn't done to facilitate or cover up the rape. The murder was the primary act, and the rape was an additional outrage. Legally, they might be prosecuted as separate crimes of murder and rape, rather than the single crime of rape with homicide.
That is a very dark distinction, but legally, I see how it changes the classification of the crime.
It does. It changes how the penalties are calculated and applied.
Okay, let's take a deep breath. We've covered a lot of dark territory. I want to move to section 6 of our outline, marital rape. This is an area where society has really shifted, right? The thinking is completely changed.
Massively. Historically, there was this archaic notion that a husband could not legally rape his wife.
The chattel idea, that she belongs to him, she's his property.
Basically, the legal argument was based on matrimonial consent, that by saying, "I do" at the altar, the wife gave a blanket, irrevocable consent to sexual intercourse for the duration of the marriage.
Which sounds absolutely horrific to modern ears, like something from the 1700s.
It is. And the current law, Article 266A, explicitly addresses this. It refers to the legal husband as a potential offender. It makes crystal clear that marriage is not a license for non-consensual sex.
So a husband can absolutely be charged with raping his wife.
Yes. If a husband forces himself on his wife against her will, it is rape. Plain and simple. The law has moved crimes against chastity, which is the old classification, to crimes against persons. It's about her personhood, not his property rights.
However,
Yeah.
and this is where I need you to explain this to me like I'm 5, because I read Article 266C and I almost threw my coffee across the room. The marriage pardon.
Ah, yes, the extinguishment of liability. It's controversial.
Tell the listeners what this is, because it sounds fake. It sounds like something from a satirical website.
Article 266C states that a valid legal marriage between the offender and the offended party subsequent to the rape extinguishes the criminal action or the penalty.
Okay, let's just pause right there. You are telling me in the year 2026 that if a man rapes a woman and then they get married, the case is dropped. He walks free.
Yes. If they get married after the rape has been committed, the criminal liability is extinguished. If he was already convicted and in jail, he gets released.
How is that possible? That sounds medieval. What is the logic, if any, behind that?
It feels medieval because it's rooted in very old traditions. The implicit logic is based on forgiveness and the preservation of the family unit. The idea was that if the victim is willing to marry the offender, she has forgiven him, and the state should not stand in the way of that union. It also comes from an older idea of restoring the honor of the victim and her family through marriage.
Restored by the marriage, that is. Wow. But doesn't that open the door to massive coercion? Marry me or I go to jail and your family's reputation is ruined. Or literally, marry me or I will harm you or your family.
Critics argue exactly that. It creates a perverse incentive for the rapist and his family to pressure, coerce, or threaten the victim into a marriage to make the crime simply disappear.
Is there any protection against that? Any safeguard?
There is one caveat. The law says the marriage must be valid. If the marriage is void ab initio, meaning it was fake from the start or legally invalid, or forced in a way that legally voids the marriage contract, then it does not extinguish liability.
So if he puts a gun to her head at the altar, that marriage is void and the rape charge stands.
Theoretically, yes, because consent is essential for a valid marriage contract. If the consent to marry was forced by violence or intimidation, the marriage is void. Therefore, the pardon doesn't apply.
But proving that seems like a legal nightmare. You'd have to go through a whole other court process to annul the marriage while also trying to prosecute the original rape case.
Exactly. It adds a huge layer of legal complexity that, frankly, favors the offender. It remains one of the most controversial provisions in the Philippine Penal Code. It highlights the tension between modern rights, where rape is a crime against bodily autonomy, and traditional codes, where it was a crime against family honor.
That is a lot to process. It really shows that while we've made progress with RA 11-48 in recognizing marital rape, there are still these ghosts in the machine.
It's a patchwork legal system. It evolves, but it carries its history with it, for better or for worse.
Before we wrap up, we need to talk about the practical side of this, the courtroom. Rape is usually a crime committed in private. It's often he said, she said. How does a judge decide?
This is the eternal difficulty of prosecuting these crimes. The Supreme Court has acknowledged that rape is an accusation easy to make, but difficult to prove and even harder to disprove.
So do you need a witness? If it's just the two of them in a room and he says she consented and she says, no, I didn't, does he walk?
No, not necessarily. As we discuss, usually there are no witnesses. The rule, reiterated in cases like People v. Balin, is that the victor's testimony alone can be sufficient for conviction.
Just her word.
If, and it's a big if, the testimony is firm, categorical, and straightforward. The court looks for consistency. They look at the demeanor of the witness on the stand. The judge watches the victim testify. Does she waver? Does her story change in material ways? In Balin, they also looked at physical evidence, torn clothing, soiled garments, as mute witnesses of the resistance. But ultimately, a credible sole testimony is enough.
But defense lawyers, Their entire job is to destroy that credibility. The sweetheart defense comes up a lot, right?
The sweetheart defense is the classic strategy. We were dating. It was just a lover's quarrel, so it was consensual. Or worse, trying to paint the victim as promiscuous. She sleeps with everyone. Why would she say no to me?
Which is disgusting, but can be effective in swaying opinions.
It used to be, but this is where the Rape Shield Law comes in. Republic Act 8505, this was another game changer.
How does that change the game? What does it do?
The Rape Shield Law generally makes evidence regarding the victim's past sexual conduct or opinions on their conduct or their reputation inadmissible in court.
So you can't put her on the stand and ask, how many men have you slept with in the last year?
You cannot. That evidence is barred unless the court, in a special hearing, finds it is strictly material and relevant to the specific case, which is a very high bar. The goal is to prevent victim blaming. The trial is about this specific incident on this specific day, not the victim's lifestyle. It stops the victim from being put on trial for her morality.
It encourages victims to come forward without the fear that their entire private life is going to be dragged through the mud for everyone to see.
That's the hope. That's the intention.
We've unpacked a massive amount of information today. I mean, we've gone from the strict biological definition of first kind to the broader gender-neutral second kind. We've seen the age of consent rise to 16 with that crucial Romeo and Juliet exception. We've looked at the severe penalties for police and priests and parents who abuse their power.
And we've grappled with the cognitive dissonance of the marriage pardon.
So what does this all mean for the listener? Why does this deep dive, this legal detail, matter so much?
I think it matters because legal literacy is a form of self-defense. Understanding that resignation is not consent. Understanding that you don't have to fight to the death for it to be rape. Understanding that your past relationships can't be used against you. That knowledge is power. It empowers victims to seek justice, and it warns potential offenders that the law is watching and has very clear definitions.
It defines the boundaries of our bodily autonomy in the eyes of the state.
Ultimately, yes. Whether it's Art 266A, first kind or second kind, whether it involves a weapon or a position of authority, the core value being protected is the right to say no and have that respected fully and completely.
And I'll leave you with this thought. We talked about the marriage pardon. It's fascinating in a very troubling way that in a legal system that has modernized so much, adding the Rape Shield Law, recognizing marital rape, raising the age of consent to 16, we still have this provision that says a wedding ring can erase a rape charge. It really makes you think about the tug of war between progressive legal reforms and these deep-seated cultural traditions about honor and family.
It certainly does. It's a provision that invites a lot of reflection on what justice really looks like and who it's for.
If you want to dive deeper into the specific cases we mentioned, like the slightest penetration rule in People versus Oscar or the bank robbery analogy for conspiracy, check the source material. It is eye-opening. Thanks for listening to this deep dive.
Stay informed.
Welcome to The Debate. Today we're engaging in a rigorous analysis of one of the most sensitive and frankly rapidly evolving areas of Philippine jurisprudence, the legal framework of rape. We're looking specifically at the Revised Penal Code Articles 266A through 266D, and of course the significant amendments from Republic Acts 8353 and 1164-8.
It is a dense and often disturbing subject, but it's a necessary one. We're really examining how the law defines the violation of a person, and more importantly, how those definitions hold up or, fall apart under the scrutiny of actual courtroom practice.
Precisely. And the central question we're debating today is one of tension between, I'd say, intent and execution. On one side, we have this expansion of legal definitions that are intended to protect victims, to shift the paradigm from a crime against chastity to a crime against persons. On the other side, though, we have these strict evidentiary standards and statutory exceptions that really complicate prosecution. So the core question is this: does the current legal framework effectively modernize our understanding of sexual violence? Or do these archaic loopholes, like the marital forgiveness clause, just undermine all that progress? I'm the advocate, and I'll be arguing that the evolution of the law represents a robust, victim-centric framework that prioritizes the violation of the person over, say, the need for physical resistance.
And I am the dissenter, and I argue that while the definitions have certainly expanded on paper, the law remains deeply inconsistent. We're seeing categorization issues, particularly around the forgiveness clause in marital rape, the complex distinctions between first mode and second mode rape, and the really subjective nature of the new proximity of age exceptions. These create a legal environment that might be precise in text, but I think is often unjust in its application.
All right, let's begin with the position statements. I want to establish why the modern definition of rape, specifically under Article 266A as amended, is, well, a triumph of legal evolution. For decades, the law focused on chastity, treating rape almost like a property crime against a family's honor. The shift to classifying it as a crime against persons is not just semantic, it is absolutely fundamental. We've moved away from a strictly physical definition that relied solely on force. The law now explicitly includes things like fraudulent machination and grave abuse of authority as means of commission. This acknowledges that a violation isn't always about a physical struggle. It's about the negation of the victim's will.
But hold on, are we celebrating the text or the reality on the ground?
I'm celebrating the framework that makes a better reality possible. And furthermore, the expansion of liability is critical. It is no longer just about penile vaginal penetration, which was the archaic standard. The law now recognizes second-mode rape, or sexual assault, which protects victims from a much wider range of violations. We're talking oral and anal insertion or the insertion of objects, and this is inclusive of male victims in that second mode, something the old law completely ignored. And we cannot overlook the rape shield from RA 8505. The law now explicitly states, and I'm citing People v. Blantz here, that the character of the offended woman is immaterial. We've stripped away the defense strategy of putting the victim's reputation on trial.
That is the theory, yes. But I view this expansion with a heavy dose of skepticism about its consistency. This expansion creates categorization issues that can really confuse legal outcomes. You mentioned second mode rape. I'd argue that the distinction between first mode, which is strictly sexual intercourse and can only be committed by a male offender, and second mode, sexual assault by any offender, it creates a kind of hierarchy of violation that may not reflect the actual trauma of the victim. Why is one treated with a distinct classification if both are supposed to be crimes against persons?
Well, precision is necessary for sentencing, surely.
Perhaps, but it leads to confusion. But my biggest concern, and where I think the law completely fails the modernity test, is Article 266C regarding the effect of marriage. I mean, we can talk about crimes against persons all day long, but the black letter law explicitly states that a subsequent valid marriage can extinguish the criminal action or penalty, and if the offender is the husband, the wife can simply forgive him, ending the case. This suggests that the state's interest in punishing the crime just evaporates if a marriage license is produced. It treats the violation as a private dispute. And what's more, the new statutory rape amendment in RA 11648, they introduced these exceptions for consensual, non-abusive, and non-exploitative acts where the age cap is less than 3 years. That introduces a dangerous level of subjectivity into what really should be a bright-line rule for child protection.
I see the outline of your skepticism, but let's move into the core debate. I want to challenge your view on the evidentiary standards, specifically regarding the definition of force and resistance. There is this persistent myth that for rape to be proven, the victim must have fought back with, everything they had.
It's not a myth if it's in the jurisprudence.
But the prevailing jurisprudence has evolved. I'd refer you to People v. Momo and People v. Savellano. The courts have been clear. Irresistible force is not required. The law only requires force sufficient to bring about the result. In Momo, the court found it was enough that the victim offered resistance until her strength gave out. It does not demand a fight to the death. The law recognizes that force is relative. It depends on the age, size, and strength of the parties involved.
I'm sorry, but I just don't buy that the standard has effectively lowered in practice. You cite Momo, but I'll cite People versus Lago. In that case, the court spoke of manifest and tenacious resistance. The phrasing they used was that the struggle must tax the victim's powers to the utmost. That is a terrifying standard. It implies that mere verbal refusal or, freezing up due to trauma might be considered insufficient without a physical struggle. If a victim shouts for help but doesn't physically batter the attacker because they are paralyzed by fear, Lago suggests that the defense attorney could argue consent.
That's an interesting point. though I would frame it differently. You're looking at physical force in a vacuum. The law has moved beyond that by recognizing intimidation. Specifically, look at People versus Alenia. The court held that moral ascendancy substitutes for determined resistance. In cases of incest, for example, a father exercising strong moral and physical influence over a daughter creates a coercive environment where, frankly, physical resistance isn't expected. The law understands power dynamics, not just wrestling matches.
Moral ascendancy is a specific carve-out for relationships, usually familial. It doesn't help the victim of a stranger or an acquaintance where that specific dynamic doesn't exist. Let's look at intimidation from a practical angle. The courts often measure intimidation by the presence of physical threats, weapons. In People versus Garcinas, the conviction relied heavily on the fact that the accused used a knife or pistol. It leaves victims of purely psychological coercion, who aren't related to their attacker, in a real gray area. If I threaten to ruin your career or your reputation, that is coercion. But without a knife at your throat, the force and intimidation element becomes much, much harder to prove under the current standards.
I'm not entirely convinced by that line of reasoning, because the inclusion of fraudulent machination and grave abuse of authority in Article 266A specifically addresses those non-weaponized coercions. But let's pivot to the topic you raised in your opening, marital rape and the so-called forgiveness loophole. This is where I believe the law has made its most significant stride. We really must celebrate that a husband can technically be held guilty of raping his own wife.
Technically.
It is more than technical. Look at People versus Jumawan. The Supreme Court applied the by a man clause of Article 266A and found a husband liable for raping his wife. This completely overturned the traditional American common law view seen in State versus Haynes, which held that marriage implies a permanent, irrevocable consent. The Philippines has rejected that. We have acknowledged bodily autonomy within marriage. That is a massive shift in legal philosophy.
That's a compelling argument, but have you considered the statutory text that remains? I'm looking right at Article 266-C. It is explicitly written, if the offender is the legal husband and the wife forgives him, the penalty is extinguished. This effectively treats rape as a private dispute rather than a public crime against a person, provided a marriage license exists. You cannot call it a crime against persons in the same breath that you say the victim can unilaterally stop the state from punishing the offender just because they're married.
Well, we must clarify the limitations of that clause. It only applies if the marriage is valid. If the marriage is void ab initio, so invalid from the very start, like a bigamous marriage, the penalty stands. The law is attempting to balance the protection of the individual with the constitutional mandate to, preserve the family unit. It's a controversial balance, yes, but it does not negate the crime itself. The crime occurred. The forgiveness merely extinguishes the penalty.
That distinction is academic to the victim, isn't it? It contradicts the very concept of rape of the second kind or first kind being public crimes. If I rob a bank, the bank manager cannot forgive me and stop the prosecution because robbery is a crime against the state's order. By allowing a wife to forgive a rape, the law is saying her bodily autonomy is negotiable if she chooses to preserve the marriage. It puts immense pressure on the victim to save the family rather than seek justice. It's a provision that belongs in the 19th century, not a modern penal code.
I understand the objection, but we must also look at the protections for the most vulnerable. This brings us to statutory rape and the amendments under RA 11648. Now, this is a clear-cut victory for protection. The law raised the age of absolute protection to 16. Previously, consent was only immaterial if the victim was under 12. Now, if the victim is under 16, consent simply does not matter. This aligns Philippine law with international standards of child protection. It removes the she-asked-for-it defense for crimes against adolescents.
On the surface, yes. But let's look closer. The law introduced a proviso that I find deeply problematic. There's now an exception for partners where the age difference is not more than 3 years, provided the act is consensual, non-abusive, and non-exploitative.
But that's a necessary nuance. We're avoiding the criminalization of so-called Romeo and Juliet scenarios. If a 15-year-old and a 17-year-old are in a relationship, should the 17-year-old be branded a rapist for life? The law is trying to distinguish between predation and, pure experimentation.
But the road to hell is paved with subjective adjectives. How do you legally define non-exploitative and non-abusive in a criminal court? The statute it attempts to define them: absence of undue influence, trust violation, but these are evidentiary nightmares. This creates a heavy burden of proof, and crucially, it opens the door for defense attorneys to argue about the maturity of a child victim. To prove the act was consensual and non-exploitative, the defense will inevitably have to probe the child's behavior, their history, their understanding of sex. We're right back to putting the child on trial to prove they weren't exploited, which just muddies the waters the law tried to clear by raising the age to 16 in the first place.
I have to disagree. The proviso specifically excludes children under 13. So there is a hard floor, but for that 13 to 16 bracket, strict liability without any exception would destroy young lives for consensual acts. The law must have some flexibility. And speaking of strictness, let's look at the severity of penalties for complex crimes. This really demonstrates the state's seriousness. Rape with homicide is a special complex crime punishable by reclusion perpetua to death. Even attempted rape with homicide is punished severely. There is no leniency there.
There's legal confusion, though. Take frustrated rape. For years, there was a debate on whether it even existed.
That debate is settled. People versus Orietta declared frustrated rape a dead provision or a stray decision. Rape is binary. It's either attempted, meaning no penetration, or consummated. And the standard for consummation is the slightest penetration rule from People versus Oscar. This is a strength. It removes the middle ground defense. Offenders cannot argue they didn't finish or didn't fully penetrate to get a lighter sentence. If there is entry of the labia, it is rape. Period.
I'll grant you that the slightest penetration rule is a strong deterrent. However, looking at the penalties, there's an anomaly regarding rape with insanity. The law treats the situation where a victim becomes insane by reason or on occasion of the rape as a qualifying circumstance. But look at the structure. In rape with homicide, the homicide is a special complex crime. In rape with insanity, it's treated differently, even though the destruction of the mind is arguably as permanent as a destruction of the body. The syllabus notes that the law doesn't say when insanity results as a consequence, but by reason or on occasion. It's a subtle distinction that complicates how we prove the causality between the rape and the insanity.
But it elevates the penalty to reclusion perpetua to death. The intent is clearly to treat the destruction of the victim's mental state with the highest severity. The law also covers rape with permanent physical mutilation or disability. The framework is comprehensive in trying to capture the full scope of the harm.
Comprehensive in text, perhaps. But let's look at attempted rape with homicide. The source material notes that this is now treated less severely than it was under previous acts which mandated death. Now it's reclusion perpetua to death. It's a slight lowering of the absolute ceiling, acknowledging that the rape wasn't consummated, even if the homicide was. It just shows a legal system wrestling with how to weigh the sexual violation against the taking of a life.
It shows a system valuing precision. But I do want to circle back to the second mode of rape because it highlights the modernization I spoke of earlier. The law now recognizes that rape can be committed by any person against any person. This means a woman can technically rape a man by insertion of an object or instrument.
Wait, let's be precise here. Second mode rape involves the insertion of the penis into the mouth or anus, or the insertion of any instrument or object into the genital or anal orifice.
Correct?
So if a woman forces a man to have sexual intercourse, peno-vaginal penetration, that does not fit first mode rape because the offender must be male, and it doesn't fit second mode rape because that requires insertion of an object into the victim or oral or anal usage. So a woman forcing a man to penetrate her is arguably still not rape under the Revised Penal Code, but rather acts of lasciviousness or another assault charge.
That is a distinct interpretation. The law defines second mode as including sexual assault, but you are highlighting the limitations of the definitions. However, the inclusion of oral and anal usage and the use of objects allows for the prosecution of cases that used to be dismissed as mere acts of lasciviousness, which carry much lower penalties. That is the victory. We have elevated the severity of these violations to the level of rape.
That is fair. The elevation of those acts is significant. But I return to my core thesis. Protections are only as good as the exceptions allow them to be. We've built a fortress of protection with these new laws, but we have left the back gate wide open with the marital forgiveness clause and the confusing subjective standards for statutory rape exceptions.
To conclude our analysis then, I maintain that the current laws, specifically RA 8353 and RA 11648, have successfully broadened the net to catch more offenders. By including second mode rape, recognizing male victims in that mode, and acknowledging marital rape as a crime, even with the forgiveness caveat, the law has modernized significantly. We have moved from protecting property to protecting bodily integrity.
And I conclude that while the scope is widened, the mechanisms of the law leave significant room for injustice. The law effectively says rape is a public crime unless you marry the victim. It says age protects you unless the offender is close in age and can prove you're mature. These are not small cracks. They are structural flaws. The law is in transition, but it has not yet arrived at a place of true equity.
I think we can agree that the text reveals a legal system in transition. It is moving away from chastity codes, but is still tethered to traditional views on marriage and resistance.
Indeed. And we would invite the listener to read the specific provisions of Article 266C and decide for themselves if forgiveness has a place in criminal law when the crime is this heinous.
Thank you for joining the debate.